Strike that.
That's right there.
Excuse me?
Mr. Caranium, did you have any reason to believe there would be gunfire in the lobby?
Yes.
Why?
Gunfire goes off. He pulls out the gun, so he goes into action. He.
Who is he?
He's in court.
Do you see the person you are talking about in the court today?
Are they listening to me?
Who?
Hey, gorgeous.
For real? Mr. Cranium.
I'm accepting applications.
Mr. Cranium.
The defendant and the other mother over there.
Do you see the person who, as you testified, goes into action here in the courtroom?
The guy who retched for his.
Yes.
Do I want them to overhear me?
Your Honor.
Mr. Cranium, please answer the question.
It's mother crazy.
Strike.
I'm upset. You crazy.
Mr. Richard, or is it Dick Cranium? Can I call you Dick? Answer the question.
All right.
Can you point to the person who goes into action?
This is getting risky, man.
Mr. Cranium, you're instructed to answer the question.
Right. Okay.
Well,
Hello. How you doing? All right. Am I talking to them or am I trying to impress them?
you're telling the court.
Are they listening to me?
Yes.
Good.
Well,
Well, I didn't take into account what he looked like. I didn't take into account what he looked like. If someone takes off and runs outside after you hear a loud sound outside, I didn't take into account first. I've vaguely seen the motherfucker. I just know when the gunshots hit, this motherfucker pull out a gun and run out.
the defendant?
Objection, Your Honor. Leading.
Sustain.
Wow. That's right there.
Mr. Caranium, when you saw the person reach for his gun, what, in your opinion, did you believe was happening?
He's robbing everybody in the house.
Do you see the person you believe was robbing everybody in the house, as you put it?
He didn't shoot me.
I understand you were not who he shot.
Objection, Your Honor. Lack of foundation.
Wow.
Actually, you can suck all these one and
That.
you get
Do
a
you see the person who pulled his gun and went into actions at precedent here in the courtroom today?
It was all too fast. Because I wouldn't remember nobody just jumping up just because they're springing out. I remember the gun, but him pulling out a gun, but him running out so fast, I wouldn't be able to just identify him. It's like a darker image of somebody running out, grabbing, reaching for a gun, and running out, responding to some gunfire.
Mr. Caranium, you are aware that you are under oath, correct?
Yes. I'm trying to do the right thing, man.
The defense calls Camille Chance to the stand.
Camille Chance.
Miss Chance, do you recall being at the bus stop on 10th and Filbert on October 17th?
Yes, I was waiting for the 43.
Did anything happen out of the ordinary at that location on that date?
Despite the fact that I was shot, no.
Do you recognize anyone in the courtroom as the person who shot you?
No.
No further questions. Ladies and gentlemen of the jury, we have heard plenty of testimony in this case, none of which proves the defendant is guilty of the crime he is charged with. The only consistency is that Mr. Lewis was armed. However, none of the four so-called eyewitnesses places Mr. Lewis at the scene of the crime at the time the crime was committed. In fact, all of the witnesses testified that at the time they heard gunfire, Mr. Lewis was in their presence at another location, which gives him an alibi for the crime. Forensics test on Mr. Lewis's weapon is negative for being fired. His weapon didn't even have a round chamber. Tests on Mr. Lewis's person came back negative for gunpowder residue. This means Mr. Lewis never fired his or any other weapon. The surviving witness, Mrs. Chance, even testified she never saw Mr. Lewis at the time she was shot. The prosecution would have you believe Mr. Lewis was an accomplice to the crime and is covering for others. Let's look at that. During interrogation, Mr. Lewis, even though he had the right to remain silent, which any decent defense attorney would encourage anyone to do with law enforcement, attempted to cooperate with detectives by asking the identity and the number of victims, something he would have known if he was the perpetrator of this crime. There's no telling how helpful he could have been if he hadn't been threatened with life in prison, at which time Mr. Lewis wisely exercised his right to remain silent and request counsel. Not that his knowledge of the crime would have been any use, since, as every witness who testified stated, Mr. Lewis wasn't present at the shooting. The only information Mr. Lewis could have provided would have been no more than speculation. Mr. Lewis wasn't present at the shooting. Mr. Lewis isn't guilty of the crime. In the interest of justice, you must and we trust you will find Mr. Lewis not guilty.